All right. Well, it seems that everybody who was ready to go right at 10 o'clock is here. So I'm sure we'll get some more people coming on. But we had still getting good participation from ABC members across the state on these webinars. I think that's a great thing. It speaks to how committed our members are to the safety of their employees, and obviously how important following the law is, especially in these trying times. I've said it over and over again. Safety and certainty are the two most important things for any business right now, especially us in the construction industry. I know I did not introduce myself at first. My name is Jeff Wiggins. I'm the state director for Associated Builders and Contractors of Michigan, based out of Lansing. Obviously, many of you are members of the regional chapters throughout the state, out in Western Michigan and Grand Rapids, Greater Michigan based out of Midland, and Southeastern Michigan based out of Madison Heights. All have been doing a fantastic job. I think I can say that, and I'm sure you would as well, keeping all of our members informed as we've jumped from new information during this pandemic over the past several weeks. But wanted to thank you for joining our call today. We're going to be talking about the governor's new executive orders that came out last week in regards to the impact it's going to have on the safety of your workers, what is needed from you, and what you need to be on the lookout for, so you can make sure, one, you're keeping your employees safe, and two, you're not opening yourself up to any unnecessary attacks or violations that could be avoided simply by knowing what's in these executive orders. I want to thank the attorneys at Miller Johnson, specifically Keith Eastland, for joining us on this call and providing us this information. It's going to be extremely helpful. And with that, I want to turn it over to Keith. Keith, are you there?
I am. Thanks, Jeff. Good morning to everyone. Thanks for taking some time out of your busy schedule. As Jeff said, we're going to hit on the construction industry provisions that you need to be concerned with in the newest executive orders, 96 and 97. And mostly, I think many of you are already operating, so hopefully this will be a review. But you can see on our agenda for this morning, we're first going to kind of make some sense out of the confusion, check in where we are with the executive orders. Then we're going to go through the current construction requirements, which as you may already know, is now going to be grouped into sort of two parts, right? We have a general requirement for all resumed activities that are permitted by the governor's executive orders, and then we have construction-specific ones, as well as potentially some others that I'll touch on at the end. Third, I think this might be the most important for many of you. We're going to talk about what's really new or different. What do you need to do to your existing plans, your existing protocols, your practices? Safety is critical in your industry. ABC, everyone on this call is a pioneer on these things. You guys have been doing this well before the governor said it was safe to do these things and operate construction. I know ABC all across the country has been safely operating during the COVID-19 pandemic. So you guys get this. I won't drone on about that, but I do want to cover what's new or different, make sure you get your policies, practices, and protocols up to speed. And then I'll just briefly touch on some enforcement issues, what's changed, and some concerns that may exist on the enforcement angle in light of the new executive orders.
Keith, if I could step in real quick, I forgot to mention, everybody, at the bottom of your screen, there is a Q&A button. So if you want, you can simply click on that and type in a question and let us know what your, if you have any questions as Keith moves through this presentation. If it's something pertinent to what he's talking about at the moment, or if it's just something that's come up in your line of work over the past several weeks and you're looking for an answer, feel free to submit a question and we can try and get that addressed during the call. Thanks.
Yep, and please ask questions because others may have the same question, and it'd be good to get that answer out to everyone. So let's start with the executive order update. So where are we? We are at 104 executive orders in 2020 in Michigan. Just to give you some perspective, and maybe some of you have already looked at this, in Illinois, there have only been 35 executive orders. In Indiana, 27 executive orders. In Ohio, only 19 executive orders during this pandemic. So the surrounding states of Michigan total have 81 executive orders. Our governor has issued 104. Talk about a lot of material to digest and figure out for businesses in terms of what they can and can't do, what they should be doing. It is really astonishing, I think, when you look at the number and the surrounding states and how others have managed to address this pandemic without creating confusion or unnecessary extra requirements and orders. But anyway, so there we go. Seemingly ever-changing. I think the governor set a new record for the time between executive orders. On May 18th, she issued executive orders 91 and 92, which set forth very specific workplace standards and requirements and retooled the structure of the stay home, stay safe, or what I would call a shutdown order. And she did that on May 18th. As we were digesting that, as our clients were, as you guys were, as members of the business community, construction industry, 3 days later, on March 21st, she changed it and issued executive orders 96 and 97. So I think that might be the record for significant change in just 3 days. It was almost unbelievable when we got executive orders 96 and 97 because we said to our clients, I know we just talked to you 3 days ago about all what you had to do, but they're completely different and changed now, and now we got to go through it. But the latest orders, the ones that everyone needs to be concerned about, are 96 and 97. And 96 establishes that's the part of that's what I will call the shutdown order. That tells us who can and can't operate. And then rather than in the old executive orders, the ones that you guys are familiar with when you opened up back on May 7th fully, the construction industry requirements for the workplace standards to operate were included in the same executive orders telling us who could operate. Structurally, the governor has now separated those two. So in 96 tells us who can and can't operate, and then 97 tells you how you must operate, what things you must do to operate. So that's a structural change there. Okay. And of course, 8-region plan, everybody probably has seen that and is aware of that, but that has now been incorporated into the governor's executive orders. Here are the 8 regions if you weren't familiar. Everyone's probably read the news stories about regions 8 and 6 being opened up for restaurants, 50% capacity, office space, and retail. Hopefully some of the other regions will be relaxed soon as well. And you may have even heard about a certain person that wanted to get their boat out in Region 6 and was told no. But anyway, those are the 8 regions. So 2 parts, I talked about this already. The shutdown order, that tells us who can perform work. It's still the same rubric. We still have critical infrastructure work as previously defined, and now we have resumed activities. And the resumed activities is where the governor is sort of relaxing everything. Construction continues to be a resumed activity. And then the workplace standards. So there's really 2 things you got to be concerned with EO 97 and the workplace standards. That is the general requirements as well as the industry specific. So you got to look at all your general requirements, which we're going to run through this morning, and then you also have to look at your industry specific requirements for construction. And then for some of you that may have larger office spaces, I'm going to run through the office workplace standards as well, just so everyone's on board with those. Okay. So what are the current construction requirements? Let's start with the general requirements. The first one is not new. You must develop a COVID-19 preparedness and response plan. You likely have these already. What is new and significant is that by June 1st, or if you haven't been operating 2 weeks after you resume operations, you must make your plan readily available to, quote, employees, labor unions, and customers. And you can do that via website, internal network, or hard copy. Okay, so what does that really mean? That means your preparedness and response plan, which has to meet certain requirements, and it references OSHA requirements, is going to get fly-specced. And it may be fly-specced by employees of your own, which is great because you want them to know, you want them to see what you're doing, and that's an effective, great communication tool, right? And that's how many of our clients and many of you have been using that. So we should welcome that. But the labor unions, interestingly, on its face, it doesn't say labor unions for your employees. So there may be an argument here that if you're a non-union contractor, a labor union, a BA on a mixed construction site might come up and say, we want to see your plan. Arguably, you might have to provide it under a plain meaning of that provision. We don't have any guidance. I checked this morning to see if there was any frequently asked questions. Sometimes the governor has posted these FAQs online that almost change daily, but there was nothing on this as of yet. So my best advice as of now is I would read the labor union provision under this bullet point as applying to labor unions that represent your employees. I think that's a reasonable interpretation absent more specific guidance, and I think that's probably consistent with the intent, which is, hey, if you have a labor union that represents your employees, well, then they would be in the position to have that information. So I am suggesting to clients that if you get asked by a labor union representative for your plan, you politely decline and say you don't, represent our employees, and go from there. How the governor and the enforcement will interpret that, we'll have to wait and see, but and we may get more specific guidance. So I know that's probably a concern for some people that prefer to remain, and obviously merit shop folks prefer to remain union-free, as is your legal right. But also employees, and so disgruntled employees or employees with questions are going to fly-spec this as well. And then when we talk about enforcement, you're going to see, if you haven't already thought through that, why this could be more significant if there's something wrong in your plan. So my recommendation is dust that plan off, compare it to all the requirements we're going to talk about this morning, and get that ready to roll by June 1st. Second bullet point, general requirement. Everyone must designate one or more worksite supervisors. I think some folks call these responsible persons, but it's clear the executive order, they must be supervisors, and they have to be responsible for implementing and monitoring your COVID-19 preparedness and response plan. You must have one of these individuals on site and designated, and people need to know who they are every time you're doing work at the job site. It can be more than one person, and they can wear more than one hat, but that is a continued requirement. Third bullet point, this is new. This is new, folks. You must provide training for your employees that covers at least the following topics. First, what are your workplace infection control practices? And so some of that's in your preparedness plan, but you've got to train your employees so they understand what they should be doing, what the control practices in place at the work site, the job site, what those are. Use of proper PPE, you already trained them on this, but you need to make sure that you cover PPE requirements under the new COVID requirements, and that gets documented as well. Third, you must make sure that you train all employees on the steps that they must take to notify you of any symptoms that they have of COVID-19, or if there's a suspected or confirmed case that they have, or that they're in close contact with someone that has a confirmed case of COVID-19. And remember, close contact, we're talking about prolonged time period within 6 feet of a person, at least 10 minutes or more. That is what we're talking about with close contact. But you got to make sure you train them on this. And then also how to report unsafe working conditions. That's probably already in your policies, your employee handbooks, but make sure you train people. Here's the person you notify of the unsafe working conditions. These need to be reported. Sometimes we've gotten the question, well, does that mean I have to tell them that they can report this or should report this to MIOSHA? I don't think this new training requirement requires you to walk them through how to file a MIOSHA complaint against you. I think the idea here is you need to make sure they understand that they can report the unsafe working conditions to who, tell them who it needs to go to, and so that any real hazards can be immediately corrected if they are, in fact, a problem. Of course, that doesn't mean that you shouldn't have your standard employee rights notices and postings up so employees understand that they have other rights, including contacting MIOSHA. But I don't think this adds a new requirement. Again, We might get something more specific in a FAQ from the governor's office, but until we do, I think a fair reading of that is just your own reporting mechanisms. Okay. Before I leave that, one thing, and I'll talk about this at the end, but I will say that if you're looking for a quick way to get this training done, Miller Johnson has put together a short 13 to 15-minute video. Some of you may have already seen it, but it will cover all these topics, and if that's something you want to show your folks, we have that available and can get that to you. All right, next general requirement. Daily entry screen for employees and visitors. This is something that you guys were already required to do. The difference between construction industry and the general requirement is that the construction industry requirement requires the employers to do this. The general requirement would permit some self-screening for employees. But you got to include a questionnaire, and many of you, I'm guessing all of you have that questionnaire. If not, let me know afterwards, and I can get you that sample and make sure you're documenting that. Continued social distancing. You got to keep people 6 feet away from each other to the maximum extent possible. We're all familiar with that. The difference, or the new thing here, is you're supposed to, as appropriate, that's the language in the executive order, use ground markings, signs, and physical barriers. You probably have seen these if you've been out to a restaurant. You know, they got these little circles on the floors, that sort of thing. I've seen X's with tape. If you need to use ground markings because of the work area to keep people 6 feet away, make sure you're doing that. If you need to put up physical plexiglass barriers because people are constantly, close to each other, put those up. Put up signs. There's no specific formula here. You got to use good judgment and common sense. You must continue to provide non-medical grade face coverings, right? We want N95 masks preserved for first responders and medical professionals, but you got to continue to provide face coverings, masks for employees. Those continue, you must continue to make employees wear them if they cannot consistently stay 6 feet apart while they're working, and you still have to consider face shields when employees can't consistently maintain 3 feet distance when working. The last bullet point is pretty much what you've already been doing. Make sure you have an increased facility cleaning and disinfection protocol and practice. You need to make sure you're hitting high-touch surfaces, avoid sharing tools. If people need to share tools, there need to be cleaning protocols in place when they're done using them and prior to the next person using them. Okay. If you have a positive case, you will need to make sure that your plan includes the protocols. What are you going to do to clean and disinfect? What areas are you going to shut down? The affected areas, obviously, you might not need to shut down the whole job site, although you probably read about the Ford plant that shut completely down. That's not necessarily required by the executive orders. If there's an affected area of the work site, you can just close that area and clean and disinfect thoroughly. This is a new one, the next second bullet point on this slide 12. Employers must make cleaning supplies available to their employees when they enter the work site. So make sure that when people come, they understand, okay, here's what's available to you. If you want to wash your hands, great, and here are all the locations for the hand washing and sanitizing places. Make sure you make that available. It doesn't mean that they have to necessarily take it with them everywhere they go, but you're supposed to make it available. All right, this one is an interesting one, and it is new. When an employee is identified with a confirmed case, you have 24 hours to provide notice, A, to the local public health department, and B, any coworkers, contractors, or suppliers, and this is interesting language, who may have come into contact with that person. That does not say close contact, right? So under this, if you have a positive case, a confirmed case we're talking about, not a suspected one, a confirmed case, on one of your job sites or on your employer premises, at your office, wherever, you must, within 24 hours, tell the public health department, and then you've got to give notice to anyone who may have come into contact with that person. And, it's a head scratcher, right? Good luck. How do we figure that out? What we've landed on as a potential strategy here for your consideration would be this. You notify the public health department of a positive case. That's easy. You document that. Then you send a letter, and I think this is good employee engagement and communication anyway, to everyone that says, hey, look, we had a positive case. This person worked at this job site on this shift on these hours, and we wanted to make sure that everyone is aware of that, so that in case you may have come into contact with that person, you too can monitor yourself for symptoms and to make sure we're not following the spread. So we kind of flipped this the second sub-bullet point into a positive one, and that's, I think, an easy way to comply with that executive order in a way that provides good, valuable notice and achieves what we're after here, which is let's make sure people are aware and on the lookout and can minimize the spread of the virus. Okay. Next bullet point. We must allow employees to return to work after they have a confirmed or suspected case of COVID-19 when they are no longer infectious as set forth in the latest or most recent CDC guidance. So now the executive order says you must follow the CDC guidance on when they can come back to work. And on the next slide, I'll talk about this is as well, but this is in a little bit of tension with Executive Order 36, which was the state requirements on when people were at risk, if they've tested positive, if they had symptoms, or if they were in close contact with somebody, they were supposed to stay home for certain periods. Well, the CDC guidance doesn't always square up with that. And the biggest difference that you should know is that recently, I think it was May 3rd or 4th, the CDC changed its guidance and said for somebody that has symptoms or test positive for COVID-19, they shouldn't come back to work. There should be 3 days where they are zero symptoms and at least 10 days from the time the symptoms began. Under Executive Order 36, many of you may know, that period was 3 days of no symptoms and 7 days from symptom onset. So now you got to wait an extra 3 days. So you're going to be out, if you have a positive test, you're going to be out at least 10 days. Or if you have someone with symptoms, they're going to be out at least 10 days rather than those 7 days. So that is a change. And one way we're handling that is modifying COVID response plans to just incorporate by reference the CDC guidance, so you don't always have to change your plan every time the CDC changes their guidance. So that's a significant point.
Keith,
yeah, go ahead.
This is Jeff Wiggins. I just wanted to, we got a couple questions here, and I think they're on point with what we're just covering now, so maybe knock them out real quick and then move on to the next slide. But we had a question from Jim Cripps. Does the daily screening for employees need to be done by the employer or the employee? And I think you said on construction, that is an employer screening process, correct?
Correct. It's an employer screening process, but I don't think. Let me clarify. So you need to track that. The employer has to develop the questionnaire, and the employer has to make the employee complete it and acknowledge it, initial it, sign it off. The input still comes from the employee, right? And so you just can't you can't allow them to self-report. Every day you should have a questionnaire that gets filled out, initialed by every person that comes on that job site, and importantly, you need to document that every day. And I know it's a big pain in the butt. I've got clients that are like, I got stacks of these papers, Keith. And one of the things that I know some clients have been using that I've worked with is, I think Spectrum Health has one of these apps where you can complete it, and an employee can complete that, and then there's a notice sent to the employer that it was completed. That is problematic unless you can show which employee completed it on which day and there's an electronic record of that. So if you're using some sort of software or application to track that, the new executive order says you must have documentation that each individual employee completed it each day. So you think that covers it, Jeff, or anything else?
Yeah, I think that's good. And then we mentioned the worksite supervisors. Would that be also required in an office setting? Obviously, we're construction, so we're mostly speaking to job sites, but obviously some of our contractor members have offices. They're in their offices now. Would a worksite supervisor be required in the office setting as well?
Yes, it would, because these are the general requirements that apply to all resumed activities. So yes. So you should have, so if you've got an office, you should have somebody designated to make sure that the COVID response, preparedness and response plan is being implemented and followed in the office, and that there's a principal point of contact there to make sure as well for reporting purposes. Yes.
All right. Thank you.
Yep. Great questions. Good. Thanks, Jeff, for jumping in. I get going here, and I'm a lawyer. I like to hear myself talk, I think. So great. All right, let's go to the next slide. So let's talk EO 36. You still have to follow EO 36, but to the extent that there is something more restrictive in the CDC guidance for return to work, remember the CDC guidance will now control, but the protections that employees get when they stay home, either because they're in close contact with someone in their family or that they worked with or whatever, they've got, remember, they got to stay home for 14 days. Of course, if you are able to have them, if they've been exposed for close contact or they have symptoms, but if they get a negative test, that's still something that will allow them to return to work. And I understand that the testing is becoming a little bit more readily available, and that becomes a big issue for your industry and you folks, because you want to make sure you have tests available for critical crews, depending on your timelines for the project. Make sure that you always have some testing available or avenue to get critical people tested, because if you have 10 guys and they're all in close contact with each other, well, if they're all out for 14 days and you need those workers to get something done, you want to have tests available in case they don't have, just because they're in close contact doesn't mean they contracted the virus. So, and that's a good business strategy, I think, to think through on that. Okay. Next bullet point: establish a response plan for addressing confirmed infection in the workplace. Again, you guys have this in place, but you should have written protocols that tells employees, when they need to go home, what part of the things you're going to close down. One important point here is to remember to tell people and instruct employees, workers, don't show up to report this. Text, call in, right? We don't want people coming to the work site if they have symptoms or believe that they've been exposed. And you think that's common sense, but I can't tell you how many stories I've had with clients that are like, yeah, they just showed up and they didn't call. So make sure that's in writing, and you can even make that part of your training so employees understand that. All right, restrict business-related travel. That's pretty straightforward. If it's not essential and you can put it off, you're supposed to do that. Encourage employees to use PPE and hand sanitizer if they're going to take public transportation. That's a general requirement. Promote remote work if you can. And then the last one is sort of a catch-all under the general requirements in this executive order that, if you're in a particular hot spot, a flare-up, a spike, there may be additional reasonable measures that you should consider taking. So, that's it's an example to me of, okay, what does that really mean? I mean, this is vague. I can't tell you what that means. I can tell you that reasonably you should look at your project, and if you're in, a city where there's a major outbreak, you might need to do some additional things, and you should at least make sure you consider what, would be reasonable additional requirements to implement, so that you can show A, that you thought about it, and B, that you took additional reasonable steps. But what that really means, it's almost impossible to say, but it's a catch-all, and I wanted to make sure that everyone was aware of it if you've got projects in highly affected areas. Okay, so those are the general requirements, and those are most of the new requirements. Let's quickly review and refresh everyone's memory on the construction industry specific requirements. Here, same thing, you got to do daily screenings. We've talked about this. We talked about the questionnaire. If possible, you need to conduct temperature screening. My guess is most people are doing this. Touchless thermometers is a good practice if you can order them. If they're available to you in the manufacturing setting, they're required as soon as they can get touchless thermometers. So I think it's very good practice if you can do it. You must document. We talked about this, the daily screening. And there's a wage and hour issue here. okay? If you are screening people for medical conditions, ordinarily under the ADA, that would be a medical examination that it would have to be supported by business necessity. The EEOC has provided us guidance that says that it's perfectly lawful in this pandemic to take temperatures, to do these medical screenings. The wage and hour issue is this. If they are waiting to get screened, because that's a medical examination, there is a good argument that for those employees that they must be paid for that time waiting because it's related to a medical examination. And so hopefully many of you are already paying that time. If you're not, you take a close look at that, look at your facts, and make sure you consult with your legal counsel to assess the risk there. I'm not saying you absolutely have to pay that in all circumstances, but I think there's a real good chance you may have to pay that. But I want to flag that issue for your consideration if you're not paying them, to make sure that you look at your facts and you're comfortable with that legal risk in that area. All right, you need to create dedicated entry points for these screenings, and then alternatively, you can use stickers or other indicators to show, on their hard hat or whatever, use a different color per day. So if an inspector comes, lost the slides here. Technical difficulties. Sorry. So yeah, so you can make sure that if someone's on the job site, it's a mixed site, they can easily identify who's been screened and who hasn't. It's not required, but it's an alternative that you can implement if you so choose. Okay. Last bullet point on this slide: provide instructions for distribution of PPE and make sure you have designated locations where people can dispose of soiled face coverings. So if you don't have those on the job site, make sure that people understand where they need to go to dispose of their soiled masks. Okay. Require use of work gloves where appropriate. That's not new. Choke point identification is also not new, right? If you've got hallways, hoists, elevators, water stations, if there's a place where people are going to be in close contact or constantly being really close to each other, you're supposed to, or you're required to, control those and minimize those choke points. Provide sufficient hand washing, hand sanitizing stations. Again, we don't have any more details on how many that is. You got to use your reasonable judgment, and you got to make sure that people, if they want to go wash their hands, they're able to do that, or sanitize their hands, they can do that. Okay. Continue to restrict unnecessary movement between projects and work sites, and make sure you have protocols for minimizing your material supplies on site, right? I've suggested in the past, you can have delivery drivers, phone in and keep their windows up, and maybe you take a questionnaire form and just record it for them, and that way you don't have any contact with delivery drivers. But I would have some documentation that you made sure that the delivery drivers that came to your site didn't have symptoms or haven't been likely exposed. And I think the easiest way to do that is with your questionnaire you're already using, and then I would either have them text the questions or call the supervisor or the foreman on site, whoever's responsible for the deliveries, managing that part of the project. Okay, so let's go through what's new or different. I kind of tried to do this as we went, but I want to just recap. So this preparedness plan availability requirement for employees, for unions, we talked about that. That's new. The biggest takeaway I would have here is make sure that you're rock solid and comfortable that that's going to be shown to your employees, and frankly, let's be honest, other people that may not have your best interest at heart, and they may fly spec that and try to poke holes in it. So make sure that you feel comfortable there. The training, make sure you get the training completed and that you document the training. Again, there's a video. My guess is you guys can put together a training module, but make sure that you cover those 4 things. In addition, it's an opportunity, remember, to talk about all the other good things that you're doing. I would use that training as a way to make people feel comfortable and demonstrate all the safety things the steps that you're taking on each project. Document the daily screenings. That's new. If you haven't been documenting, you may have to show that if you get asked. We talked about this broader notice requirement. That's new and one strategy at least to deal with that. The CDC guidance now on returning employees, and I included the link to the website so you can take a look at that, or if you have questions, happy to answer that. Make sure you update your positive test protocols to incorporate these new changes. And then the making of supplies available upon entry for employees. That's new, as well as the business-related travel restrictions. And those are what's new. Okay. Additional thoughts that I have, I included this slide on a previous webinar, and I'll just go through it quickly. Food for thought, more or less. Make sure you're communicating with your owners, the general contractors, construction management firms, meeting everybody's expectations and coordinating efforts on the project, right? I mean, we want to make sure that there's a combined effort. We don't need one or two subs that aren't doing things the right way, and then that causes an outbreak, and all of a sudden, you know, it's in the news, and, you know, the governor's looking at, oh, maybe we need to, you know, ratchet down, you know, construction operations because we can't maintain a safe work environment. So we want to make sure everybody is on the same page. Make sure if you're a general contractor or construction manager, or if you hire subs yourself as a contractor, that you have a plan and you let your subcontractors know contractually and otherwise what's expected of them. So there's no doubt about that. Communication strategy for your own employees. You probably have those. If you don't, make sure you develop them. What are you going to do? How are you going to communicate things? What are you going to do on employee travel? I've gotten a number of questions on this. What if I want to go to Chicago because my brother's sick and I got to go to a hospital there? What are you going to do there? There's nothing in the executive order that says that just because I visited some out-of-state location that I can't come back, but you know, what's that going to do to the workforce? Do you want to impose some sort of voluntary restrictions, or are you satisfied that, hey, these daily screenings are good enough and we're going to social distance and we're good enough? But employee travel is an issue that really hasn't been addressed specifically by the executive orders, and I want to make sure that it's flagged and you've thought through what's the best way to handle that for your organization and on your projects. Don't forget about FFCRA, related leave issues, refusals to work. I saw an article the other day talking about how unions plan to utilize the COVID-19 safety issue as a rallying cry for union organizing. And don't think for a moment that if there's an outbreak on a project that that might not be used. I mean, I think it will be used by union organizing. If you're concerned about that with your workforce, make sure you're thinking about how you're going to address refusals to work, that sort of thing. There's legal risks, obviously, in addressing those things. We're not going to cover those today, but I want to flag those. We've covered those in other webinars. You can go on our website and check that out, and if you're interested, or happy to answer questions separately. And just make sure everyone understands, what are the parameters for a positive test? What is going to happen? What are the requirements for a return to work? And they're going to change, right, these CDC requirements. So make sure whoever's in charge of the responsible person, that is going to manage your COVID response plan, they need to be up to date and understand those requirements, and make sure all the leadership on the project understands that as well. Okay, the next two slides, I'm not going to go through these in detail. I put them in here because I wanted you guys to see if you have office workplaces. These are written more for, Miller Johnson, where you've got an office, with 3 different businesses and you got 100 people coming into the office. That's what the lens through which they are written. But a plain reading of the executive orders would say if you have an office where you've got 10 or 15 or 20 or 30 people coming, you should be complying with these as well. And they're there. You can read through them. But you can see the level of detail that this executive order goes into. I mean, you got to do things like turn off your water fountains. Make sure that people wipe down their workstations. For Eastland, it would be his phone and his keyboard and his desk in his office, and I got to wipe that down twice a day. When I go walk around the hallways or go to the bathroom, I have to wear a mask. We're supposed to post signs. All these things need to be accomplished if you're in the office workplace. And there's the rest of them for you. You guys can take a look through those. But, disinfect high-touch areas. That's, a lot of this is common sense, but I wanted to make sure to the extent that you have office facilities that you're aware of those requirements and that they exist. These slides will be available after the webinar as well, so you can go back and read those closely. If you have some sort of business that is connected, I'm sorry, go ahead, Jeff.
No, I was just going to point out for everybody on the call, in the chat section at the bottom of the screen, Amy has provided the link to all of Miller Johnson's COVID-19 webinar, PowerPoints, and recording. So once this is all done, both the PowerPoint and the recording of this webinar are going to be up there, so you can go back and review if you missed something.
Yep, thank you. Good point. Good point. Yeah, and I think they're available on our website, but that link would be super helpful if you're interested in going back. And the nice part about that is you can listen to them anytime you want. Can't sleep at night or something. Okay, talk about enforcement issues, and then we'll leave some time for questions. So obviously safety is huge. You guys know that. And the enforcement issue is not about safety, right? The enforcement issue is a concern because right now the governor has relied on two statutes for her authority to issue executive orders. Putting aside whether her emergency extension through June 19th, whether that's lawful, everyone probably knows that's being challenged in court. Can she unilaterally just continue a state of emergency forever? Putting that issue aside, assuming the governor has the authority to act under these laws, both of these laws make it clear that the enforcement penalty protections are only for willful violations. So you got to prove that somebody willfully disregarded these requirements, and that's going to be enforced through local law enforcement and through criminal proceedings. And remember, criminal proceedings and our Constitution gives us certain protections, right? You got to prove that I've committed the willful violation beyond a reasonable doubt. I have many other constitutional protections, the right against self-incrimination, the right to a jury trial, all those things, okay? And the reason that is, I believe, is because when the legislature says if there's an emergency and you're acting, we don't want to penalize employers that are trying to sort through this and are acting in good faith and doing the best that they can, right? What you want to penalize is when someone just says, thumbs their nose at the governor's rule and says, I'm not following this, and I think you can't make me, right? That's a willful violation. That's what we're talking about, okay? And that makes sense to me because you're saying, okay, these are emergency rules. 3 days later, you're changing them. We're constantly trying to figure out what's new. You've linked to CDC guidance that changes. So if we make a mistake, right? If I don't wash down my station twice a day, I do it once a day, or 10 people don't get screened because somebody missed them. Should that be a violation that's subject to punishment and fine? Well, it wouldn't be unless it was willful under the laws through which the governor has acted. However, in her newest executive orders, the governor said, no, all of my requirements in the executive orders are the same thing as formal agency rules, as if they would have been adopted through the rulemaking procedures that are available to the agencies, like my OSHA, right? And every one of these requirements, including that catch-all vague thing that she says, well, you got to impose other reasonable efforts based on the infection rate in your area. Well, what does that mean? Well, if I get that wrong, now I'm subject not only to a MyOSHA investigation, but the fines and the penalties and the framework. And that does not include a willful violation. That does not include proof beyond a reasonable doubt. That is simply, by a preponderance of evidence, we believe an administrative law judge and an agency, which the governor controls, decides you violated the requirement. Now you're subject to a fine. Now you got to challenge that in MyOSHA, and everybody knows what that means. If you get MyOSHA violations and you have a significant number of those, well, that makes it pretty darn hard to get work. especially in the construction industry. So these enforcement issues are a concern for many folks, including ABC, not because of the safety issue, but because of the procedure issue and the precedent that it sets. And so I know you've read about it, but there is a lawsuit on this, and the lawsuit is essentially asking the court, asking the court to tell the governor, look, you want to act under these emergency laws, you need to follow the penalties in those laws. You don't get to pick and choose which laws apply to you and which don't. No one's above the law, and it's about adherence to the law. And so that's what the litigation is about. And so if you hear things, and my guess is there's going to be folks out there that want to make it a safety issue, it's really just not. And so I wanted to touch on that at the end of this. And certainly I'm sure Jeff is available to answer any questions that you have on the lawsuit. Just a real quick plug for Miller Johnson. If you're a client, thank you. If you're not, we do have something called a Back to Work Resource Center. We've put together best practices, best forms from anything from executive order compliance all the way through HR, FFCRA leave, notices, sample protocols, training videos. We've put together this Back to Resource Center. If you're interested and you want to check it out, here's a link to it. It'll be updated with all the most recent construction materials by the end of the day today, and we are updating this periodically. So the idea is it's sort of one-stop shopping. You can just go there whenever it's convenient for you. We do have industry-specific pages, so if things come related to construction, we'll post those on there. So if you want to check that out, feel free. Jeff, I'm going to open it up. We got about 12 minutes. Before the hour, so if there are any other questions that you see that's come in.
Yeah, and one based on that link that you just put up, that resources link, was the 13-minute training video you referenced earlier. Is that going to be at that link right there?
Right. That's part of the package that we offer, and it's like a subscription service. And all of our training videos are on there, but we also are selling that for a modest fee. I think it's $200 or $250, and then you can show it to all of your employees. So if you're not interested in the whole resource center, we do. I think our marketing folks have put that together for anyone that wants to purchase that and show it to their folks.
Got it. We received probably 3 or 4 questions on the Q&A tab, and all surrounding how the relationship between the general contractor and the subcontractor operate on a job site. So, for example, if you're a GC and you're subbing out 100% of the project, is it the GC's responsibility to make sure to have to be running the job site operations when it comes to COVID screening, testing, reporting, etc., or is that something each individual subcontractor is going to have to have in place for their company?
Yep, I'll give you a lawyer answer.
Right.
It's both.
Depends.
Right. That's the lawyer answer, right? So if you have the ability to control the work site, so if you're a general contractor, but you maybe have 2 guys, or 3 guys or something, and you sub the whole thing out, you're still in control, my guess is, because if you look at your contractual agreements that you have in place, I guarantee you have control over that. So the executive order imposes an obligation on all construction industries to do this. So the general contractor, and we have this we've put this together. It's a sample plan that you can give to your subs. Okay, this is what we're doing, but then if you're going to work under us through a subcontractor, here's what is expected of you. And so yes, those subs should be doing that. And the subs, right, because if you're a general contractor, you don't want to have to be responsible for screening every single person that comes in that job site. You want to be able to delegate that, and you can do that, but you need to make sure that it's done in a way to show that you've acted reasonably to ensure that your subs are doing what they're supposed to do. Because if the sub doesn't do it, and they don't do it, and they don't do it, and then there's no monitoring of that, I do think that the executive orders, the way they're written, would allow the governor, and if these new fines and this new rubric under MIOSHA is upheld, those fines could be assessed against both the general, the construction management, and or the subs.
All right. Keith, do these rules expire or become invalid at any time, or are they just kind of in perpetuity for right now?
They expire on June 12th is when the shutdown order is. So that's a very good question. So when the governor broke this up into sort of who can operate, the shutdown order, and then these workplace standards are separate. And the workplace standards don't have an expiration date, but they are incorporated and linked by reference to the shutdown order. So their expiration dies with the shutdown order, because the shutdown order says if you're going to be resuming construction or operating in-person business, you must comply with the workplace standards. So that's incorporated by reference. So currently they expire June 12th, but they can be extended to the extent that the governor believes, and if she is found to have the authority to continue the emergency she is extended through June 19th, and her MO, the governor's MO, has been about a week before, so to extend the emergency and then to change the shutdown orders and to continue them. So right now they expire June 12th. They're likely to be extended and or modified, hopefully not in the next 3 days.
All right. As you're screening employees as they come onto the job site and somebody doesn't pass the screening process and are sent home, is that somebody, would that person be covered under the Family First Act?
They could. It depends, right? If they meet one of the leave eligibility requirements, right? If they have symptoms, if they test positive. So that's something when you send them home, and again, you should have a form, that you can give to people if, and remember, this is for employers under 500 employees, and it's measured at the time of the leave request. But if someone needs leave, I think you can give them that form and they can check it. And if they meet one of the requirements, then yes, they may be entitled to the 2-week sick leave the 2-week sick leave, because that's not a child care issue, so the Extended Family Medical Leave Act wouldn't apply. And we've got a form for that. If someone would like that, I'm happy to share that with you. And so when someone gets sent home, you can have your HR people follow up and ask the question, right? And because remember, under the Family First Corona Response Act, you're entitled to a credit on your quarterly tax is for those payments. So if you need to make sure that they get paid for that, you're going to get reimbursed in theory through the tax credit. So that's something you're going to want to follow up with employees on.
On a similar note, if a symptomatic person winds up testing negative, are they able to return to work after testing negative, or even if they're somehow still symptomatic? And then in the same note, can you require a symptomatic person to get tested? Right.
So yes, you can. I don't know that you can require them to get tested just generally, right? I mean, you can suggest that they should go get tested. Can you require them to get tested to come back to work? I think there's an argument you can. The EEOC said that you could do that, but then they changed they removed that guidance, and so people are shying away from that. But I think that is probably legally defensible to say, no, if you want to come back to the job site, you got to get tested. With respect to if someone is symptomatic, like I have I have a cough, right, or I have a fever. I mean, I can get a fever for non-COVID issues. If you get a negative test under Executive Order 36, which is supposed to be followed, you can return to work. Now, the CDC has guidance for if somebody's been hospitalized. So if someone tests positive and they've been hospitalized, they're supposed to have a negative test and not have a fever without fever-reducing medication. So there's a little bit of a difference there. So if just someone that's symptomatic and they haven't been treated and they haven't tested positive and been in the hospital for COVID, if they have a negative test, EO 36 says they can return to work after the negative test. And as I understand the science behind that, there's very low risk that you're going to have it if you have a negative test. And that I think that's the way EO 36 was written. If for some reason somebody's in the hospital, then the analysis becomes a little different. And if you go to the link on that website, on the link to the website on the previous slide, you can read directly. The CDC has the guidance there on. There's a link to the in-hospital employee situation I was referring to.
Got it. All right. We'll try and get in a few more here. Has a separate order been issued that governs how to handle visitors to an office or a work site, or basically do the same kind of rules apply?
Same rules apply.
Got it. Okay. You said something about sending a letter out to those who may have been in contact with a tested positive individual. And I think we got a pre-submitted question on this as well. Basically, trying to figure out how many is too many people knowing, the confirmed individual's identity who has tested positive. So for this question, you said something about sending a letter out to those who may have been in contact with a tested positive individual. Would we include that tested positive individual's name?
No, I would not. Not unless you have permission to use it.
So
you want to protect their medical privacy there. And so the letter would simply say, if it was on job site at, in Lansing, you would say, okay, on Lansing on this project, this person worked on these days. We're sending you the letter because you worked on those days, and I would send that to all the subs and everybody so they know that there was a positive case, confirmed case of an individual on that site in those areas on those dates, right? And you got to use reasonable judgment. So, you don't have to tell the whole world, but you should cast a broad enough net to make sure that if someone reasonably may have come in contact with them, and that's not close contact, right? That's just any contact. There's some judgment calls that need to be made there, but that's how I would approach it.
Got it. You mentioned earlier that I think if there's a positive test on a job site, that you have to report it to the health department. If it's a confirmed COVID case, wouldn't the testing facility where the testing happened be reporting that to the health facility or the health department also?
They should, and in theory, that's how it ought to work. They should know before you know, but I can tell you that I've had 5 or 6 clients to learn and get called by employees before the public health officials are, and I think that's exactly why that was added in the executive order, because for some reason the public health officials aren't learning about all the cases.
Got it.
Which makes sense. That's why they want people to tell them in case they missed it. Understood.
Are you aware of any contractors in our industry actually being cited for any violations of these executive orders? Has anything come across your desk or maybe the firm regarding a violation of the executive orders that are currently in place, whether it's these or any of the other ones?
Not yet.
Okay. All right.
Okay, great. I see it's 11 o'clock, so I'm going to sign off here. And I apologize, I do have a hard stop. I got a federal judge that expects me to be on the line in 1 minute. So I'm happy to answer additional questions if you want to send them to me or give me a call. But I do thank everyone for their time.
All right. Thank you very much, Keith. And I know we didn't get to some of these questions in here. I think we got about 5 or 6 left. We're going to take them and parse through them and try to get answers to the folks who asked them. If you were an anonymous attendee, didn't provide your name or email when you called in or signed up, I know I see some of these on the questions here. It says anonymous attendee. If I didn't get to your question, please feel free to email me. I'm at Wiggins. My last name is Wiggins @abcmi.com. Happy to work with the folks at Miller Johnson and try to get answers to all of your questions. Again, appreciate you taking the time today, and stay safe out there. Thanks again.
Thank you.